let's talk about your rights, specifically your rights against search and seizure in the state of Indiana. Now, most people have heard about the Fourth Amendment to the United States Constitution, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That is the federal standard. But Indiana has its own version, specifically Article 1, Section 11 of the Indiana Constitution. It uses almost identical language to the Fourth Amendment, so you might assume that the protections are exactly the same. But Indiana actually offers more protections than the federal standard. In State v. Washington, the Indiana Supreme Court made it clear. Even though the wording is the same, Indiana interprets Article 1, Section 11 independently from the federal courts. This means that Indiana uses its own legal test to decide whether a search or seizure is reasonable under state law. Specifically, Indiana uses a balancing test from Litchfield v. State that looks at three factors: the degree of concern, suspicion, or knowledge that a violation has occurred, the degree of intrusion the search or seizure imposes on the person, and the necessity of the search in relation to law enforcement objectives. Indiana's search and seizure rules are spelled out specifically in Indiana Code 3533-5. Here's the basic idea. Police usually need a warrant. That warrant must be based on probable cause, and it has to describe the specific place to search and the items to be seized. Indiana also recognizes certain exceptions to the warrant requirement, including consent, where you let them search voluntarily, exigent circumstances, like an emergency situation or the risk of evidence being destroyed. The automobile exception, if there's probable cause to search a car. Search incident to arrest. This means searching a person and the area around them after a legal arrest. Plain view. This is if the police see the contraband in plain sight. Even if these exceptions exist, though, that search must still be reasonable in order for the evidence found to be admissible in court. So, how does this apply to DUI cases? In DUI cases, the initial traffic stop must be supported by reasonable suspicion that a law was violated. This can include swerving, speeding, or expired tags. Under Indiana's Article 1, Section 11, courts will analyze not only just whether there was a legal basis for the stop, but also how intrusive that stop was and how necessary it was under the circumstances. For example, did the police have specific and articulable reasons to suspect intoxication? Was the stop brief and limited in scope? Was the intrusion proportionate to the concern? For example, field sobriety tests or breath tests. Was that proportionate to the concern for the stop? While all of this is allowed under federal and Indiana law, Article 1, Section 11 requires that the request and execution of these tests be reasonable in both suspicion and scope. In the case of Ramos-Osorio v. State, the police stopped Mr. Ramos-Osorio because they heard gunshots, allegedly, coming from his vehicle. The police thought his truck might have been involved, even if they couldn't pinpoint the exact location of the gunshots. So they stopped him. It was only then that they noticed signs of intoxication and arrested him for it. The Court of Appeals said this wasn't reasonable enough for a stop under the totality of the circumstances. The cops did not have a reasonable enough suspicion for stopping him. Therefore, anything that came after that was unreasonable too, and the conviction was ultimately reversed. Vehicle searches after a DUI arrest are also treated pretty differently. While federal law often allows searches of a vehicle under the automobile exception or as a search incident to the arrest, Indiana law asks whether that search was actually necessary and how much it intruded on the driver's privacy. If the search was broad or not directly related to the evidence of intoxication, Indiana courts might suppress that evidence. This standard even applies for the blood test. Indiana has implied consent laws, so if you're arrested for a DUI, you automatically agree to a breath test or a blood test. You can still refuse, but that comes with consequences like an automatic license suspension. But what if the police force a blood draw without your permission and without a warrant? Under federal law, they might claim exigent circumstances. It's an emergency. But under Indiana Article 1, Section 11, the courts look at certain things, like was the draw really necessary? Could they have gotten a warrant in time? Was the person unconscious or refusing? If not, the court might toss that blood test, even if it shows you were over the limit. If Indiana courts determine that a DUI stop, search, or test violated Article 1, Section 11. The resulting evidence, like the blood alcohol concentration results or officer observations, may be excluded from trial. That can lead to dismissal or reduction of those charges, especially in borderline or low blood alcohol concentration cases. If you have any questions, give us a call at 317-632-3642. And remember, always plead the fifth.